legal lots. And kind of the format is I'm gonna stand up here and I'm gonna talk, but I'm gonna interact with you. So as you have questions, just feel free to interrupt me as we go along. Since there's such a large number of people, relatively speaking, if you could try to ask questions that might be relevant to everyone else versus like a specific piece of property that you have, unless you think that's gonna be useful to everybody else. That'll help us get in and out of here within an hour. So, but I will try to make it quick, but every single one of it is legal lots. It's like walking in a bog. It's like you stop and then you start sinking because the details just go on and on and on, and it gets more confusing and as you dig into it, kind of thing. So I'm going to try to keep kind of a broad overview. I'm happy to answer questions afterwards too. I'll hang out, and again, if you have questions as we go along, just let me know. So, any questions so far? Yeah?
Could you speak louder, please?
Okay, I'll try to. This is about the volume I can go, but I'll do my best. So I have a handout that I put up front, 2 sides to it, real basic. The first item talks about lot creation types. Now most of you, when you think about a lot, you think about a tax lot that you see on the tax map, and that's sometimes a legal lot, but it's not a legal lot. I mean, it can be a legal lot or it can not be a legal lot. There's no real truism between the two. Tax lot is just a lot for tax purposes only. So to figure out what you're paying taxes on. The legal lot, completely different. So I'm going to start with the very easy lot creation types. You have subdivisions and land partitions, which I'm sure a lot of you know about. That is a legal process that you go through with the jurisdictions, the cities, the county, and you end up with a lot or parcel at the end that is a legal lot, period, until you start moving the lines, and then you start making it potentially illegal again if you don't do it properly. The third type is deeds, which is a meets and bounds description describing a piece of land. You're transferring it from one owner to another. That's the third way. And typically, any issues you have with legal lots will come along in that third category. The land, subdivision, and partition, as long as the lines haven't moved, you're usually golden. So if you're looking at your tax map and you see that your property is lot 5 of whatever subdivision, and you don't see anything on the map that looks like maybe a line's been adjusted, or in the legal description, if the legal description still calls it out as that legal lot, that platted lot, then you're good. You don't have to typically worry about anything else. Any questions yet? Am I talking loud enough? Can you hear me? Probably not. So legal lots matter the most in Lane County proper, not in the cities. Also the city of Eugene, the city of Veneta, and that's about it. Springfield has legal lot, it acknowledges legal lots, but they don't really pursue legal lots. So if you're selling someone a parcel in Springfield and they go in for a building permit, the city is typically not going to look and see whether it's a legal lot and tell them they need to make it legal before they get a building permit. Springfield doesn't like legal lots because they kind of hamper development. Lane County loves legal lots, and they love to tell you you don't have a legal lot, and it becomes extremely complex the further you dig into it, because you have Land Watch out there appealing pretty much every legal lot decision to make it more and more complicated to make a lot a legal lot, or to determine that a lot is a legal lot. So some important dates. Most of Lane County is in, well, Eugene and the area right around Eugene, Springfield is in a 1962 zone, which means that if your property was created by deed after April 2nd or May 2nd, 1962, you might be in trouble, and you want to look into it. For the most of the county, if it was created by deed after March 26, 1975, same thing. You want to be sure that you understand whether your lot's illegal or not. And these are just guidelines. It doesn't mean they're automatically illegal or automatically legal if they're before that, because it gets more complex. In Lane County, you have a 1949 subdivision ordinance. So what that means is any land divisions, creation of 3 or more parcels in a calendar year will render some of those lots will become invalid because they were created after 1949. So for example, and I'll use this a little bit. A real simple example is if you have someone owns a property here, they die in 1951, and they have 4 kids, and they deed each of these out to their 4 kids. The first one and the second one out are legal from a temporal standpoint. So if this one was deeded out to the first kid in January, this was deeded out to the second kid in February, this was deeded out to the 3rd kid in March. This lot is illegal because you created an illegal subdivision. This is in 1951. So fast forward to 2016 and say this person has had this property they inherited from their father, you know, that long ago, and they die and pass it to their kid goes in to get a building permit, and the county says, this is an illegal parcel, illegal lot, you can't build on it. So that 1949 date is also problematic. Anything created prior to 1949 is typically okay, but Lane County is still gonna make you pay a bunch of money and go through a process to tell you that it's okay. So that's the 1949 date. Cottage Grove has a little area around it, 1970. But it's typically, you're still dealing with Lane County because Cottage Grove isn't gonna typically make you go through a legal lot process either. Only Eugene, Veneta, and Lane County. But in Springfield, you can also use it to your advantage if you think you have 2 legal lots that might have been combined. And you can find the deeds for each of the 2 parts that existed prior to 1960. You can go to the city and say, hey, I think I have 2 legal lots here. Here's the deeds. They'll say, yes, we agree. You can get 2 building permits. You don't have to go through a land division because the lots already exist. Does that make sense so far? So real quickly, the remedy for an illegal lot is called a validation of unit of land. And the 3 basic rules are that it has to be an illegal lot. You have to have it determined to be an illegal lot. And this becomes really complicated in Lane County because they won't agree that your lot is illegal until you've actually gone through some kind of a process to show them that it's illegal. They don't like to agree that your lot is legal, so they also don't like to agree that it's illegal, so you get kind of stuck in the middle here trying to figure out which path to take. They're very unhelpful with that, and it's problematic. Anyway, the first is you have to have an illegal lot, has to have been created by deed prior to 2007, and it could have been created legally at the time that it was created. So those are kind of the 3 base parts of validating a unit of land. So if you're in the 1975 zone and you have a piece of land that was created in 1977 and it's illegal, but that could have been approved as part of a partition, has enough area for the zoning, has enough frontage, whatever, then you have a remedy available all the way up until 2007. Yep.
Would we presume that it's legal though, if let's say that's a corner lot and those 3 lines are easements onto the property? Would easements be given if they presume that it's a legal lot?
That's a whole different question. Easements would be completely different than lots, but these are fee simple lots that are actually deeded to someone else.
Okay.
So if you retain ownership of the whole parcel and you're letting someone use it, you still own the whole parcel. But once you deed out a portion, then it becomes its own separate lot, and it's either legal or illegal, depending on how and when it came out of the parent parcel.
Hey, Jen?
Yep.
If you have a lot with a permitted structure on it, that guarantees it's a legal lot.
No, not at all. In fact, you have a lot of these kind of quote unquote loopholes or closings. So say you're in Lane County, and you're trying to replace a house that's on any parcel, residential, farm, forest. You go through a verification replacement right process, and you have two types. One's a type 1, which means you're gonna relocate your new house within 142 feet of the original house. That's a type 1, it doesn't go out to notice. Lane County so far is saying you don't need to prove up on your legal lot status. But if it goes further than 142 feet, you get into a type 2, goes out to notice, Land Watch gets it, the county will require that you have a legal lot to replace that dwelling if the parcel is illegally created.
What's the loophole that's closing?
So we have a project where when you do a replacement dwelling, you have options. One is you build your new dwelling, you tear down the old dwelling. The other is that you continue to use that as a guest house, you decommission it as an actual house, or you use it for something like storage. But if you do those kind of things, it elevates your type 1 to a type 2, and then suddenly Land Watch is involved again because they get notice of that. And so what they're doing is they're coming in and saying, on this project we have, they're saying, you haven't proven up that this is a legal lot. They're sending that comment into the county, and we're saying to the county, we didn't think you had to have a legal lot if it was the same site replacement. They said, that's how we've always done it. Now, just because that's how they've always done it, doesn't mean that Land Watch couldn't appeal that and win and close that. If that makes sense. Any other questions? Does that make sense so far?
So properties can be transferred regardless of whether they're a legal lot or not, so.
They can, but there is
Where?
an ORS that says that you should not, at the bottom of the front page, it says that it was improperly created. Essentially, your buyer would have a remedy if they went in, found out it was illegal, they could come back to you as the agent or the seller, or maybe both, I'm not sure.
Oh, great.
And so that's kind of the important part of understanding what it is that you're selling or that you're helping your clients sell.
Isn't there a time limit on that statute?
If it happened before 1949? I don't know about the statute, I'm not an attorney. But you just wanna you'd wanna know that there is a statute out there, and it's cited right here. And if you were worried about it, you should check with an attorney, for sure.
If a person, buys a piece of property that has been disputed, and they go through the court process and they get it satisfactorily determined to be a legal lot, how many years later can they, resell it and feel secure?
Well, the legal lot wouldn't be established through the court system, it'd still be established through the county.
Okay, the county said yes, it got appealed by Land Watch, and then they went to court and they got it okayed.
Yeah, so once it's determined to be a legal lot and your appeal periods have passed, it's a legal lot. So at that point, it's transferable, because you have the documentation that shows, as long as you're not moving anything after that determination, you should be good.
So I heard if you get verified as having a legal lot or some verification with the city, that you should appeal it in order to get a judgment that can't be changed.
If you have a legal lot,
Yeah, I was told that if you go to the city and you get something approved, you should appeal that approval in order to get a letter that, makes sure it's unchangeable. But have you ever heard of that?
I have not.
No, it's-
Are accessory dwelling units implicated relative to the legal lot status?
It's a good question, I don't know. And it kind of branches out into a bigger question, like in Eugene, where you have middle housing now, so you can go in and put up to 4 homes on a single lot. If you have do you need to prove up on your legal lot before you go in and you put those homes? I'm not sure. you need to prove up on the legal lot before you do a middle housing land division after that. I'm not totally sure about that either. And you think I know this stuff, and I know a lot about it. I have two people in my office who know much more than I do about this.
Well, that's not true, Jed.
Totally true. So, and the more you learn, it's kind of one of these, the more you learn, the less you know kind of things. I know a lot of these things because we've gone through them. But the rules, especially in the county, are constantly changing. Because every time Land Watch appeals something and they have a victory with the hearings official, then the rule doesn't change, but the interpretation changes. So then you have to, the next application has to adhere to that. What we're finding out in Lane County is that we've come in with the next legal lot application, and they're ignoring their most recent hearings official decisions and ruling based on past decisions. So we're in the middle of a couple of those now. So your ability to even rely on these interpretations is on shaky ground right now too. It's a mess. So at the bottom it said, why do you need a legal lot? Building permit. In order to do a land division in Eugene, Lane County, or Veneta, you have to show how your parent parcel is legal. They require that. None of the other jurisdictions so far require that, but it is required in those jurisdictions. Special use permits in Lane County, most of them, like a replacement dwelling, forced template dwelling, non-farm dwelling, all of those need legal lots to begin with. And then transfer of property, that's that ORS section I was talking about down at the bottom, which you'd wanna probably get some legal advice on that one. And on the back, I just have like a little kind of highlight, like what you have in a lot of the South Eugene especially, is you have a lot of these old subdivisions. And you have lots that go across them in a lot of different ways. So this section here, and you can look at it later if you want, it's just kind of an example here of, here's the original subdivision from like 1911 or whatever it was down here at the bottom. And here's the most recent tax lot. You can see the 27 in the middle of the tax lot corresponds with block 27 of the subdivision plat. And you can see how the platted lots lie there underneath. Some are dashed lines, some are. Some of these lots were built in a north-south direction, even though they're platted in an east-west direction. So depending on the year, if a lot of these were deed transfers that happened prior to 1962, you may end up having multiple legal lots already existing on a single tax lot. It becomes less important now because you have middle housing, which allows you up to 4 houses per lot. But if the lot's already there, your ability to transfer title to it exists like right away. You probably want to get confirmation from the city of Eugene, for example, and something like this. Show them the deed that created that part of your lot prior to 1962. Get a letter from them saying they agree that it's a separate legal lot, then you could sell that piece off. Or build on it and refinance just that piece. You not have to worry about a standard land division or a subdivision or anything like that. Okay.
So in order to protect our clients and I guess ourselves, we just need to be making sure that if our property that our client's buying for is created by deed, if it's after these dates, we don't have to worry about it,
If it's before those dates,
then we,
the only date you don't have to worry about is if it was created by deed prior to 1949.
okay.
Anything from 49 to whatever the cutoff date is, whether it's 62 or 75, you have kind of what you could call land watch creep in Lane County, which means that it used to be fine if it was before 75 or 62, but now they've opened up the 1949 can of worms. And so all these transactions that happened, almost 100 years ago or whatever, 80 years ago are now invalid, which is crazy.
Are you a member of Land Watch?
Yeah.
And then, I was just wondering, is there a part of Eugene that's more susceptible to these issues?
Nope. I mean, the highlight here, like I said, West University, south of campus, South Eugene, there's a lot of older plats. Whitaker neighborhood has a lot of old plats. So if you're looking for kind of like diamonds in the rough, it used to be more, like I said, before middle housing used to be more relevant, and it still kind of is, but you could look and you could see, you know, here's 3 platted lots, but in 1950 they were divided this way. And so my lot has 3 pieces of platted lots. So each of these 3 could be legal. And that has value because you don't have to divide anything. You can build on it right away, you can refinance it, you can sell it.
Is there a minimum size?
There's not.
Gosh.
Yeah.
As a course of, like a best practice, would you advise people then if they're, gonna buy a piece of country property that they would get it surveyed, or what's the best course for them to verify? Short
So,
of trying to go to the county and wade through it.
so usually I just advise people to reach out to us. I mean, if you send me an email, my email's on the top of the sheet there, and you just say, we're looking to buy this property. If it's a property that has a house on it, and all you're doing is buying the house and continuing to use, you have no intent to do anything different, you're probably fine without worrying about a legal lot. But if you plan to replace the house at some point, or divide the property, or do something different that might require that, you'd wanna find out ahead of time. And then what we do is we go through, just some real simple first steps. One, you go to the Land Management Division website, which any of you could do. You can put in the, map and lot number, and then you can look and see if there's been a legal lot determination already done. If I had to estimate, I'd say of all the properties in Lane County, maybe 10% have actual legal lot determinations that are completed. So even if it's not platted, you'd go look there first to see if it was determined through a legal lot process to be legal. The second thing we do is look at, I think it's a little more in the weeds, the CIDO, which is the surveyor's website, has a button for land partitions and divisions that happened prior to 1990. And you have to click on each image that pertains to your township section and range to see if your lot is there and it was actually divided through a minor partition. The minor partitions aren't gonna show up on your tax map. Subdivisions and partitions since 1990 will show up on the tax map. And your parcel or lot will have a number listed. So if you're looking at this, you know, you have down here the original plat. If you look up here on the tax map, you can see the lot numbers in the corner of each individual lot. And a lot of them have the same numbers because they're both part of the same parent parcel. So that's the second thing we do is kind of take a quick look at the minor partitions prior to 1990. And then the third thing we do is pull up the deed card and look through the deed description and see if there's any indication of something having happened in the past. And when you're looking at a piece of land and you're thinking, this is one tax lot, but it's pretty big, I wonder if there's more than one legal lot inside it, especially in the county, because you don't have middle housing in the county. But if you have 2 lots, sometimes they're worth twice as much than if you had 1 lot. So as you're looking through the meets and bounds description, you may not be able to kind of follow the math, you know, like, but what you can see is there's certain language that is used on these, and also, which is a lazy surveyor's way of like revising a legal description when you add adjacent property to a lot. So instead of having to re-describe the whole thing, they just attach the deed for the next property that's being added, and say, and or also.
Have a lot that has a 3-foot strip between two lots, there's no man's land, nobody owns it, it doesn't show up in paper, but when you surveyed it, they said there's a 3-foot piece. How do you handle that?
That's a difficult question. If you can't find a deed, it's, what it probably is a survey gap. So
They said,
different.
as fair as that one guy started at one corner, one came to the other when they met, there was 3 foot left over.
Yeah, so that's typically a survey gap, but I'll tell you, we're working on a project in Springfield that has a survey gap like that. Somehow or the other, this person got ownership, a deed from Lane County, and he actually has a deed that created a parcel out of that gap that doesn't even exist. So I mean, it can happen that it becomes something when it's really nothing, but typically it's nothing.
So, excuse me, if you have several contiguous legal lots and you do either lot line adjustments or lot line removals, does that trigger a legal lot challenge?
No.
No.
But if you have multiple legal lots in the county and they're adjacent and they're zoned F2 and you didn't transfer them out of ownership prior to January 1st, 2019 into separate ownerships and they're all under the same ownership, all of those legal lots have now become one tract and you can only get permission for one home now instead of one for each home. And that's House Bill 2225 that caused that to happen.
Regarding your gap issue, we ran into that once out in Coburg with about a 3-foot little triangle piece. And we actually brought in the 93-year-old wife, the surveyor was deceased, and brought the 93-year-old wife in and she signed over that little piece and took care of it. So there are resolutions, sometimes they're just a really unique go around to make that happen.
Yeah, it'll probably depend on the facts and the dates that it was created.
Going back to your 3 steps to do, the number 1, you mentioned a place to look. What was that?
The Land Management Division, from the Lane County website, it's like LMD Pro, I think is what they call it.
So what do you type in first?
The map and lot number, and then.
No, back to where do you go in first?
Oh, just to Lane County's website.
Lane County and then where?
The LMD Pro.
LMD?
Yeah, I'll put it up here. I don't have the actual address. And you click on your results, you'll get like all the building permits, sanitary sewer records, any planning applications, so like legal lots, special use permits like templates or non-farm dwelling, whatever approvals there have been over time. Well, they won't always show up there, but a lot of them will.
Will it be obvious if it's a yes or no answer?
Nothing in Lane County is. On this one?
Yeah.
You just type in, you find LMD Pro that has a field for the address or for the map and lot number.
Right.
And then you just enter that in and then you click go find it or return or whatever.
Okay, so that's the next step, is that step 2, okay.
Well, that's the first, that's all one step for me. The second step is CIDO.
Is what?
It's Lane County's CIDO.
But that's not for us, correct?
Well, it
Or is
just gets-
CIDO for us?
CIDO is the surveyor's website.
But do we have access to it?
You do, yeah, everybody has access to it. It just becomes a little more technical. When you're looking, it's the same thing, you're gonna, it's kind of an antiquated search system, so if you click on the button for land divisions prior to 1990, then you enter in your township section and range. You can't put in the tax map and tax lot. There's not enough fields, you can only start with those 3. It'll give you all the results in that whole section, and then you click on each one and you look and see whether that's your property or not. Knowing that tax lot numbers, a lot of them have changed over time. So if you're looking at something from 1970 that's tax lot 700, it might be tax lot 1300 today. So you have to kind of look at the shapes and where the streets are and the north arrow and all that, and find it that way. It's a little, it's pretty clunky.
So Jen, I'm curious, when we get our list kits from the title company, is there anything that should flag us that we need to ask a little more questions, like with your map here, when you see this kind of thing, and with lots, especially in town, they're oriented different directions and the dash lines, are there things that we should see, that we should ask about, does it really flag that?
Dashed lines are frequently an indication that something has happened. So yeah, dashed lines.
And how far should we dig into that if we represent a seller?
It depends on your objective, I think, you know, if you're just trying to sell a house, and the house is the main asset, no one wants to do anything different than live in the house, you may just be wasting time. But if it's somebody that wants to see if they have something that they can sell off easily, like they were initially thinking, I'll buy this property, I'll do a land division, which might cost, 25, 30 grand. And it might take 10 to 12 months to create a parcel that they can sell. If the parcel already exists, and all you need to do is submit the documentation to the city and get a letter back from them agreeing, then you can sell it right away.
Cause I'm seeing this happen like in the Friendly Street neighborhood, some of the parts in town where the lots are now big enough that it could be partitioned, and it's like, the question is, well, when do you ask that answer, or ask that question about that? And dig in?
And like I said, subdivisions are gonna show up, like you can see this gross addition, it says gross right there, on the tax map, you can see the whole thing. And then you can see blocks, the 27 to 28 are the blocks. And then the actual lot numbers are in the lower, corner, either right or left. So you know that it's probably a platted lot or a portion of a platted lot. Those are kind of indications. You can look at if you can look at this one right here at the bottom, right at the corner of whatever street that is and whatever street that is, right in the middle. There's lot 7 is that whole section that belongs to 3 different parcels. So it's under 3 different ownerships. So the question is, because these lots went this way, you look at some of them, it looks like, there's a couple there that might have 3 legal lots inside them.
For in, say Eugene, if a buyer were gonna go to the city and do their due diligence before they bought a parcel like that, can you rely on the city giving them accurate information?
I mean, legal lots are more cut and dry in Eugene, so if you have a deed that, shows these things happening prior to March 26, 1962, it's pretty solid. In Lane County, you get into a whole bunch of interpretations that say, yeah, this piece that came out in 1962 is legal, but the part that got left behind is not legal, which doesn't make any sense. But there's, and so that's why, honestly, I don't think it's a good idea to go to Lane County and ask them about legal lots.
So at that point, we have to call you, right?
Yeah, I mean, we can look at it, I look it up, I don't charge for that person, just kind of quick look and tell you what it is. I mean, ideally, you call me up and I look it up real quick and I'm like, yeah, this is a platted lot, here's the subdivision, kind of thing, it just saves everybody a lot of time.
So I had a buyer looking at a large lot down near Lorraine, where there was a 1910 plat that showed a bunch of different lots underneath it. And so I was asking around to see if we could use those, and I think it was the county came back and said, no, those are decommissioned.
Those are right next to the old track,
I think so.
so I think I know the lot, and if that's the lot, then I think you probably have at least 2 legal lots and maybe 3.
Right.
But we can talk.
Yeah, but, once something's decommissioned from 1910.
If it's vacated,
Yeah.
it just doesn't automatically decommission, you actually have to vacate it. Someone has to go through and remove those lines through a process. The county can't just say they don't exist anymore, because the county likes to not exist.
But if they say, yeah, this shows it's been vacated, there's no going back.
Right.
From a vacation. Right. Gotcha. Thank you.
So you can have multiple legal lots in one tax lot, can it go the other way?
Multiple tax lots and one legal lot, we can, yeah.
And then if you've got multiple legal lots in the one tax lot and you decide to develop those, does that development process include just subdividing it into the tax lots?
Well, it's more problematic when you have multiple legal lots inside one tax lot. Usually it means that people have bought the pieces. So if you reassemble all the pieces, say you buy all the tax lots back to rebuild your initial legal lot, then you have one legal lot. You don't get to go in and build on the tax lots.
And then if you have the tax lot with the multiple legal lots, and then you decide to build on each
that point, all you have to do is make sure you comply with the zoning. And if it's a substandard lot, generally the rule is, it's still good. So if you go to places, it'll get contested, so you go to places like Monroe, like where the old brickyard was. And there's like these huge like company cities kind of thing, you know, that have a bunch of 25 by 100-foot lots. There's hundreds of them out there, and they're on big parcels that, like one tax lot may have 200 parcels in it. You know, and they're zoned residential because they're inside the urban growth boundary and the city limits. So can you go and build every single one of those out? By state law, you probably can. But you have to reconcile it either amenably or legally with the city. Kind of thing.
Yeah, and on that lot, there was a neighbor that brought a lawsuit and made the minimum lot size like 7,000 or something. So-
Right, but the question still remains, if it hasn't been vacated, you know, do you have a legal right to be able to build on it? Regardless of, I mean, because it was created in 1911, which that plat was, you know, and the city came up with an ordinance in 1985 that said you have to have at least 5,000 square feet. Does that preempt this platted lot? In Lane County and Eugene, if you have a legal lot, they'll let you do whatever you can do on it as it sits, even if it's substandard.
So they'll just do utilities and they don't care?
Well, yeah, I mean, the utilities are typically there in the city, so but you're gonna end up paying SDCs and the city will get a benefit, you know, for connecting up with each legal lot. Yep.
So a situation, what if you have you think is a legal lot, your seller purchased the property, it had specific CC&Rs when they purchased the property that it could not be subdivided as such, but in investigation, you find out that they actually purchased the property and it wasn't a legal lot to begin with. So there's that overlay. Obviously that would be an attorney that would need to get involved, but so the previous seller or whoever created the CC&Rs.
So they have two problems. One's they've illegally created the lot, and two is the CC&R that says only one home per lot. As Rick knows, Rick's still around here. Rick knows all about that CC&R. We did a 36 lot PUD over on Hawkins Lane that had one house on it, the house that Rick lived in. And the deed restriction said only one home per lot, so the city gave us approval for 36 lots. But the neighbors appealed that because of that deed restriction, went all the way to the Court of Appeals, and they said, Rick's house is already on that lot, that's the only house that 10-acre lot gets. So you're done.
Nice.
So that's an important deed restriction to keep your eyes out for if you're trying to.
Yeah.
But if there's an underlying subdivision from 1911 and then there's a 1950 CC&R that says you can't divide it, well, it's already divided, you know, and then that becomes more of a legal question.
Okay, thank you.
Any other questions? How we doing? We got all sorts of time.
I kinda wanna know from title, what does title catch in any of this? Is there a specific thing we can buy to cover ourselves on this?
Yeah, I don't know, it's a question for your hosts, I guess. I mean.
Yeah, Cynthia here to answer that question. Yeah, so, she is actually out of the office this week, but, yeah, that's something that I would, need to take to my title department and title officer, and that's a question.
I mean, the biggest issue is, especially in properties in Lane County, is that the answer is so convoluted that no one's gonna know unless they go through the whole process with Lane County, you know? So I mean, Western Title's not gonna look at a property and go, this is an illegal lot. I mean, who knows if it's illegal or illegal until you've paid like 10 grand to go through a process for 8 months.
Or would there be a cloud on the title?
Yeah, I mean, I don't know. don't know if it's excluded somehow, it's and if you think about the jurisdictions that actually care about that, and the jurisdictions that don't, it's just a weird, almost anomaly kind of thing. I don't know of any title companies in town that are keeping their eye out for legal lots, you know? Yeah.
I don't know if you work in other counties or not, but is this just in Lane County, or is this all over the state?
The complex part is just in Lane County. We've done stuff in Douglas County for the Boy Scouts. We submitted, they're titled different things. They're legal lots here, they're lots of record in other counties. And we went through this big parcel and we said, we think there's 3 different ways to look at your ordinance. And this way you have 9 lots, this way you have 12, this way you have 15 or whatever. And so we submitted that to the county probably a year and a half ago, and the woman who was processing it finally stopped returning my calls. Because I think she just looked at it, she's like, oh my God, I don't know, you know. And we did the same thing out in Coos County, lots of properties. And they seem to be fairly sophisticated out there about it, but it's like Springfield, it's like a benefit. It's like you submit an application saying we have 10 legal lots here, and they review it according to the deeds, and they say, we agree. Or you submit an application to divide it, and whether or not it's a legal lot doesn't matter to them. So, just like Springfield, this doesn't matter, they don't wanna think about it. So, and it's just kind of, over time, I'm sure it'll evolve. We keep hoping it'll devolve, because it really is kind of blackmail, is what it is.
Oh, yeah.
In my opinion. And they've made it so complicated that it's just unusable, almost.
What's the status with ADUs right now on county property?
I don't know much about them, but I think that if you have at least, I think 5 acres, or 2 acres, so 2, yeah, that you can build an ADU, or you can get permission to build an ADU.
And
But I
they're
also,
not being challenged by land watch?
I don't think so. I mean, they typically focus on farm and forest property, although they love to show up at hearings where there's like legal lots on a residential, and then they want to wrap themselves into it and respond to it. We're doing that right now with them. It's ridiculous. But I don't know about the legal lot question that was asked earlier. Like, do you need to have a legal lot in order to get an ADU? I don't know the answer.
But ADUs are only on RR properties, and forest properties, there's none allowed.
Right.
Yeah.
But on forest property and residential property, if you have more than one legally established dwelling and you have a legal lot, so you have like 2 or more homes on one legal lot, and those 2 zones, you can divide between and sell them off, regardless of the size of the lots.
Say that again, can you repeat that?
So if you have a legal lot that has, it's zoned either residential or F2, and the dwellings are determined to be legal, you have building permits or some kind of evidence that they were legally established, then you can divide between those, regardless of the lot size. So even the big game stuff that's happening in F2 for template dwellings wouldn't apply to that. Exciting stuff.
Jed, is there a book that you can recommend that kind of describes this stuff?
Dracula.
Right.
I mean about this stuff?
Yeah, so it's mostly, you've got to read the case law, the land watch decision.
And I mean, our office, in my mind, is kind of, apart from a couple land use law offices, it's kind of like the last bastion or stronghold of property rights in the county. Because I have one person that does legal ops full time, and another person who's been an attorney for the last 25 years defending them in Lane County. And then the 3 of us together looking at these and assessing them and coming up with an approach and probability families and then arguing at the county level to get these things done. There's no book. It's kind of one of these things that if it doesn't change, and we all die off, then everyone's gonna be screwed.
You drive up to a property, tell me your first 5 red flags when you see a property that we should look for.
I don't even drive to them.
I
I pull it up on the computer. I honestly, we've done I've been doing this for 27, 28 years, and we do a lot of land divisions.
So dashes.
I've probably been to 10% of the projects we've actually divided that I've actually been to. It's all, you get more detailed information on a computer than you do walking up to a blackberry field piece of land kind of thing. But anyway, that wasn't what you meant, so.
So dashes, I know you said is
Right.
one.
Yeah.
What else?
Well, another one is just the size of the property. You know, if you're looking at a property that's 30 or 40 acres or larger, that's in an area that's got a lot of homes or smaller lots, it's worth looking into. Doesn't mean that you're gonna have something there, but it's worth looking into. That's another one. Do you have a question here?
So, I mean, you keep saying Lane County, but then you're like, but Springfield doesn't care. So, does Junction City care? Is it really just Eugene and Benita?
Benita. Even Florence doesn't know, you know, they haven't dealt with it yet.
And Cresswell, me.
The planner at Cresswell used to work for me.
Oh.
He'll probably avoid legal lots as long as he can.
Okay.
But I think, Oak Ridge,
Marcola?
no, I mean Lane County, so, yeah, it's just Veneta, oddly enough, and then Eugene and Lane County. Like I said, I mean, you can look at stuff in Springfield and you can say, this looks like maybe there's more than one legal lot. You go out and you find the deeds to support that. They'll send you back an email agreeing with you, and then you're done.
Oh my gosh.
Yeah.
What year did Lane County start requiring building permits?
I have no idea. I found them back in the early 70s. I haven't really seen anything before then. But if you can find documentation that a house existed prior to 1970, so far the county has been amenable to considering that legally established. But that's kind of a real gray area.
So if you have two obviously old houses on one parcel, you theoretically could divide that place?
If it's residential or F2 and it's a legal lot. All right?
So if we have a client that has questions and concerns about that, they can call you.
Yep.
Right?
Yep. And my email's at the top of that sheet.
Do you put people through the Eugene legal law verification process, and how long does that take?
A lot quicker than, probably about 2 or 3 months, maybe.
But you can, isn't there like an initial, just a verification if it's a legal law, or is that?
That's what it is.
And that's
Essentially, you
3
pull
months.
together documentation and you submit it to the city.
Perfect timing for us, right?
In disputes on legal lot verification and just when people look into it, where does the responsibility usually land?
Lane County is supposed to find, when things are ambiguous, they're supposed to find in favor of the applicant, but they never do. So they'll make a decision. If it's an approval, in the 13 or 14 days after the approval passes, no one appeals it, you're done. If it's a denial, you have that much time to appeal it. And then it goes to a hearings official who decides whether the county was wrong or not. And then it's the same kind of thing. If they feel like the county was wrong, they'll reverse the decision. Then you have a longer period to wait because it could get appealed to LUBA right now. Trying to get it so that the Board of Commissioners gets back into the fold and they can actually get that third level locally instead of going at a time.
Say you have a 1 acre parcel, but it's zoned EFU. It's a very old house. Red flag? No? That's fine if the zoning is.
If it's a legal lot and you want to replace the dwelling, you should be able to replace it all. If it's a legally established dwelling.
But we should make sure it's a legally established dwelling if the zoning is.
Unless they just want to live in it. Then it's, you know, I mean, you know, hypothetically, someone could buy a piece of land that has a house that was illegally established without a building permit, and the county would come in and tell them to tear it down. That could happen. So that's, you know, I mean, does it happen? I don't know. Any other questions? I'll stick around if anybody has any questions.